Case 80, Huerta v. Pirker. We find ourselves here in administrative law courts, with the ALJs, the administrative law judges of the NTSB. Facts. Raphael Trappy Pirker remotely piloted an unmanned aircraft, a right-wing Zephyr, in a series of maneuvers around the University of Virginia campus in Charlottesville, Virginia, on October 17, 2011. Respondent operated the unmanned aircraft at altitudes ranging from extremely low 10 feet AGL up to 1,500 feet AGL. Respondent operated the aircraft inter alia directly towards an individual standing on a sidewalk, causing the individual to take immediate evasive maneuvers so as to avoid being struck by the aircraft. Through a tunnel containing moving vehicles, under a crane, below treetop level over a tree-lined walkway, under an elevated pedestrian walkway, and within approximately 100 feet of an active heliport. Respondents allegedly conducted these maneuvers as part of flights for compensation, as the aircraft was equipped with a camera, and respondent was being paid by a third party to supply aerial photographs and video of the UVA campus and medical center. Respondent appealed the administrator's order and subsequently filed a motion to dismiss the complaint as a matter of law. The administrator contested respondent's motion, and the law judge later permitted additional pleadings from the parties. The law judge's decisional order granted respondent's appeal. The administrator of the FAA now appeals the decisional order of ALJ Patrick Garrity, issued March 6, 2014, vacating the administrator's order of assessment against respondent. The assessment ordered respondent to pay a civil penalty in the amount of $10,000 based on a violation of 14 CFR 9113 for alleged reckless or careless operation of an unmanned aircraft. The law judge's order terminated the enforcement proceeding against respondent and found 9113 did not apply to respondent's unmanned aircraft because the device was not an aircraft for purposes of the regulation. So what's the issue? Whether 14 CFR 9113 applied to respondent's unmanned aircraft. The court reversed the law judge's decisional order and remanded for further proceedings. Reasoning. Let's first discuss the ALJ's decisional order of March 2014. Citing the FAA's 1981 Advisory Circular 9157, setting forth safety standards for model aircraft operations, as well as a 2007 policy notice, Unmanned Aircraft Operation in the NAS, Notice 0701, the ALJ explained that the FAA has distinguished model aircraft as a class excluded from the regulatory and statutory definitions of the term aircraft. The ALJ further stated, by affixing the word model to aircraft, the reasonable inference is that the administrator intended to distinguish and exclude model aircraft from regulatory provisions applicable to aircraft. Accepting the administrator's position that respondent Zephyr was an aircraft, for purposes of FARS, the law judge reasoned, would result in the visible argument that a flight in the air of, let's say, a paper aircraft or a toy balsa wood glider could subject the operator to the regulatory provisions of 14 CFR 91 and 9113. The FAA administrator took the position that the Zephyr at issue was an aircraft, and that its determination in this regard was consistent with the administrator's regulations at 14 CFR Part 101, promulgated in part on authority of some of the statutory provisions underlying 9113, which imposes specific operating limitations with respect to unmanned free balloons, kites, rockets, and moored balloons that rise or travel above the surface of the Earth. The language of 14 CFR 91.1 specifically excludes these aircraft as well as ultralights from the requirements of Part 91. Instead, 14 CFR Parts 101 and 103 contain regulations governing these types of aircraft. Though they are subject to special operating rules, the unmanned devices covered under Part 101 nonetheless are aircraft. The regulations contain no text suggesting the administrator considers those devices to be something other than aircraft. In fact, Section 91.1, in excluding the devices from the ambit of Part 91, specifically refers to the devices as a subset of the term aircraft. The administrator's position in this matter, that respondent's unmanned aircraft is an aircraft to which 9113 applies, comports with the regulatory approach contained in Part 101.